Good afternoon, everyone. Thank you very much for coming to today's seminar. It's truly wonderful to welcome back Professor Hamish Stewart from the University of Toronto to give us a seminar. Traveled all the way very recently here, and it's a great honor and very special for me because Professor Stewart was my teacher in evidence when I was studying at Toronto many, many years ago. And particularly special and honored that I was in his very first evidence class. And I still actually have his notes from that class. I don't know how many of you can say that about your classes. But it's always great to be able to welcome Professor Stewart back. And today's topic is also quite new. We've had lots of events and seminars on artificial intelligence and the law, but I think this is probably our first one in relation to criminal law. And hence, I understand that we have quite a few people who've signed up for today's event. But I imagine this will be really quite a fascinating discussion of this topic, probably very preliminary, and we'll probably have more conversations about this in the future. With that introduction, Professor Stewart, may I invite you to give your talk.
Thanks very much, Simon. Simon is correct that he was in the first evidence class I taught many years ago. And you may not believe this to know him now, but he was very quiet in class, as a matter of fact. So anyway, it's great to be back at Hong Kong University. The last time I was here was in June 2018, and it's an understatement to say that a lot of things have happened since then. But I'm not going to talk about any of the things that have happened since then, except for some developments in AI. I want to thank Liu Sada for the invitation, and Candy Ip and Flora Lung for making all the arrangements for me to stay here. So my topic for today was announced as something along the lines of, can the criminal law be penalized? Reflections on AI and penal liability. So I want to begin by confessing that I really don't know very much about AI. I know a lot about criminal law, I think, but I don't know a great deal about AI, and you will see that unfold, I think, in a certain way in my presentation. My interest in this topic was prompted by two things, two factors. First of all, like many of us, I think, I was quite startled when ChatGPT was released last fall. I was quite, I have to say, I've never used it myself. So everything I know about it is other descriptions from other people of what they've done with it. But it seems quite remarkable. Pardon me?
Hearsay.
Hearsay. No, it's only hearsay if, oh, never mind. We won't go into the definition of hearsay right now, because I could talk about that for an hour easily. Very impressed by the way people described its powers and slightly alarmed. So I began reading a little bit in this area, and I discovered what I should have known already. It turns out that my law school, the Faculty of Law at the University of Toronto, actually has several faculty members who've been working on AI issues and the law for some time. And I'll just mention some of their names in case you're interested. Ben Allery, Abdi Aidid, who's one of our relatively junior colleagues. We just hired him a year ago. Anthony Niblett and Albert Yoon, all of whom are very enthusiastic about the potential to improve the law through AI. But I also have some colleagues who are more cautious and a little more skeptical. My colleague Gillian Hadfield, who knows a lot about these issues, is quite concerned about some aspects of AI and has written some very interesting work on this topic. And my colleague Lisa Austin, whose areas of interest might be best described as privacy, data management issues, something that obviously intersects very significantly with AI. So I've been reading the work of my colleagues and of other people who've written in this area. And in reading the literature, and I can't claim to have read it all because there's a lot, but in reading the literature, I was struck by what seemed to me the absence of some very basic questions about the relationship between legal AI, what I'm going to call the legal AI, and criminal law. There seem to be two basic questions here which have not been asked, or if they have been asked, have not been considered very seriously, although, again, I may have missed something. And one is a question about what I will call the domain of application of AI. What kind of legal problems can it actually help us with? And in particular, can it help us with some characteristic problems of criminal law? And the other relates to the extent to which failure to comply with the directives of a legal AI should be punishable conduct. So I'm going to begin by giving you my understanding of some basic ideas in this area. And then I'm going to use those understandings to explore these two questions. It would have been tempting to come here with answers to these questions, but I don't have answers to these questions. So this is mostly to raise the questions and hope that people will think about them besides me. So there are three terms I'm going to be using throughout the presentation. The first is, I'm just going to say the legal AI, and I say the legal AI instead of just legal AI because it's meant to summarize a kind of technology which particularly my colleagues Abdi Aidid and Ben Allery have predicted is going to come sooner than we think. And this, what I refer to as the legal AI, would be a technology underpinning what they call in their work on this topic, a stable and complete legal order capable of addressing and resolving practically all types. I see there's some words missing in this quotation. I'm sorry about that. Addressing and resolving practically all types of legal uncertainty in real time and on demand. Now that's quite a remarkable promise when you think about it. If you have a legal question, according to the vision of Aidid and Allery, in the future, instead of combing through the law books as we did when I was a student, or combing through the legal databases, even with the assistance of the kind of tools we have now to inquire of them, get a bunch of statutes and cases and try to extract some principle from them, which might be right or might be wrong. Instead, on their vision, at some time in the future, not the very distant future in their view, you're going to be able to ask a machine. It will tell you immediately what the answer to this question is. So when I use the expression, the legal AI, that's what I'm going to be referring to. This is not something we have yet, but it's something that is coming, according to my colleagues. The second phrase I'm going to use is personalized law. There's been quite a lot of writing recently about personalized law. And the idea of personalized law is that it would be a set of norms whose content would be adjusted continuously to take account of, and again, here I'm quoting from the work of two scholars who've written about this, to take account of the differences not only across situations, but also between people. So that's the second term I'm going to use. And the third term, and the one I'm mainly going to be concerned with here, is the phrase microdirectives, which as far as I can tell was coined by Anthony Casey and Anthony Niblett in a series of papers they've written on the application of AI to legal problems. A microdirective would be a command that was generated by the legal AI, by this technology that's supposed to be coming, and would be conveyed to specific individuals in real time. Now, that's a little bit abstract, so it might be helpful to have in your mind an example of what this might look like. And the example that's often used in the literature on this topic is, I'll just go ahead one slide and then I'll come back. The example that's often used in the literature on this topic is highway traffic regulation. So the idea is that highway traffic law, presumably, is intended to strike some kind of a reasonable balance between safety of users of the road on the one hand and convenience of users of the road on the other hand. So you want to get where you're going as quickly as possible, but of course you want to do it safely. And as anyone who's taken another course that I taught in the past, introductory economics, as anyone who's taken introductory economics will know, there's going to be a trade-off between these two things. Presumably our highway traffic law embodies some kind of trade-off between these two values. It may not be apparent to us what it is, but it's got to be in there somewhere, or at least so the economist would say. So the promise that is being held out to us by proponents of the legal AI is that if we inform it what we want this balance to be, it will calculate in real time exactly what each of us should be doing while we're driving. So instead of having a speed limit on a highway, we might have different speed limits for different times of the day, or different speed limits for different people in different situations, depending on their ability, depending on their level of experience, depending on maybe even factors like their fatigue, how long they've been up, how long it's been since they last had a cup of coffee, or whatever factors are relevant to safe driving. So this idea of micro directives can be illustrated by the idea that while you're driving along in your car, just as a footnote, these are also people who believe we're going to have self-driving cars. So if we have self-driving cars, all this is not going to matter. But let's just set aside the self-driving cars for the moment. The idea is that you would be driving along and you would be continuously responding to what the AI was telling you to do in order, and it would of course be doing the same thing for everybody else on the road at the same time. And the overall effect would be a better balance between safety and convenience. That's the promise. So just going back one slide, the supposed advantages of microdirectives are that it would eliminate legal uncertainty. That is the aspect that's strongly emphasized by Aidit and Ellery in their book. That it would better achieve legislative objectives because the volume, just as ChatGPT can do incredible things with the amount of data that it has, so it's envisaged the legal AI would be able to better achieve whatever the legislative objectives were by calculating all the variables relevant to the situation and issuing demands accordingly. And third, and this is a theme that's been stressed by Casey and Niblett in their work, and also by others, it would force us to better refine what our objectives are. To go back to the example of traffic regulation for a moment, I said a few minutes ago that our highway traffic law presumably embodies some trade-off between safety and convenience. But I don't think any of us has any idea exactly what that trade-off is. And I don't think the legislature does either. And proponents of the legal AI say, well, in order for this to work the way it's supposed to, we'll have to be more explicit about what those legislative objectives are. We will have to be clearer about those things. And that will be a further advantage in their view to the use of the legal AI to generate micro directives to tell us what to do. So standard example, highway traffic regulation. Another example that's often used in this context is medical negligence. Negligence more generally, but medical negligence is one that's often specifically used. Sorry, let me go back to the previous slide again. In the advantage of personalized law and microdirectives is supposed to be that it will ultimately enable us to get rid of both standards and rules. So as I'm sure you know, in jurisprudence, there's a very standard contrast that many scholars have drawn between legal standards, which are inevitably vague, drive carefully, and rules, which are more specific, but may not be able to take account of all the necessary variables. Don't drive faster than 100 kilometers an hour. What advocates of the legal AI are holding out to us is that we'll be able to get rid of both rules and standards. Standards are vague. In principle, they could be made complete, but we don't have enough information to do that, so we'll use the legal AI to do it. Rules are not vague, but they are inevitably over-inclusive or under-inclusive, sometimes both, with respect to the particular objectives that they're aimed at. So the idea is that if we can specify directly what the object of the law is and calculate what people should do in order to achieve that objective, we won't need either rules or standards. We'll just have this series of particular commands known as microdirectives. That's the promise. Now, so I'm reading all of this stuff and I'm wondering, well, this sounds pretty amazing, amazing potentially in a good way, amazing potentially in a bad way. But the question I couldn't help but ask myself is how is this supposed to interact with criminal law or with penal law more generally? Most of the literature that deals with the relationship between AI and penal law has to do with its application to decision-making by judges and other legal officials in ex post adjudication. So something has happened and now we need to decide what to do about it. Or ex ante predictions of risk in contexts such as sentencing or determining eligibility for bail. So there have been quite a number of studies where it's been claimed, and I'm not capable of assessing these claims myself. There have been quite a number of studies where it's been claimed that various forms of AI do better than human judges in applying the factors relevant to granting or refusing bail. So the law of bail obviously differs from country to country, from jurisdiction to jurisdiction. In my jurisdiction, there are 3 criteria for refusing bail. The first is the concern that the defendant won't appear for his trial. The second is public safety. And the third is a rather vaguely defined public interest criterion, which I won't go into right now. In many jurisdictions, even if they don't use those exact 3 factors, the concerns around granting or refusing bail are generally the same. Is the person going to show up for trial? In the interim, does he pose a risk to public safety? And it's been claimed that AI does better than human judges in making those determinations. Better in the sense that it does a better job of minimizing the degree of public risk and maximizing the probability that the accused will show up for trial than the human judge would. Now, those are not the kind of applications I'm concerned with today. I'm concerned with what you might refer to as ex ante applications. That is, situations where the AI is directing us as individuals to do specific things in order that we will comply with the law. So it's not about predicting risk. It's not about predicting recidivism in the context of sentencing, for example. It's about trying to make it easier for us to comply with the law as it applies to us. For today, I'm going to set aside questions about whether AI would work. And what I mean by whether it would work is whether it would do a better job, whether it would do better at the job that was assigned to it than a human decision maker would. I'm not going to assume that it's perfect. I'm just going to take for granted that it could do better. I have doubts about whether that's true, but I'm not going to challenge it today. I'm just going to accept that as a possibility. If you're interested in those possibilities, I've just given you one paper, but there are many others that are there's many papers on this problem. I'm just going to assume that's not a problem for today's purpose. I'm also going to set aside claims about the rule of law. Some people, in response to the AI, in response to the promise or the threat, if you prefer, of legal AI and the microdirectives, have claimed that there's something about generality that's essential to the nature of law. So law is essentially general norms that are applicable to everyone in general and are made specific in specific situations by judges. Some people have said that's essential to the nature of law. They may be right about that. But again, I'm not going to take on that today. I'm just going to set that aside and not worry about it for the purposes of today, because I want to ask some questions that arise, even if the AI works as promised, and even if there's some argument to say that it's not contrary to the rule of law to use it. And these are my questions. Now, as I said earlier, I wish I could have come to you with answers to these questions, but I don't. They're really just questions for the purposes of today, and I'd really be interested to hear what people have to say about them. So I'm definitely not going to fill my whole hour with me talking. And so I'm going to pose these 2 questions with associated reflections. And the first has to do with applying the idea of microdirectives in the context of what you might think of as the core of criminal law. So as I said before, the example often given in the literature has to do with highway traffic regulation. What about the law of murder and theft and drug trafficking, sort of core things that you deal with if you're a criminal lawyer? Are microdirectives of any use in that context? And my tentative answer is no, because in that context, microdirectives would be either useless or pernicious. And I'll explain what I mean by that in a minute. The second question I want to deal with is whether failing to comply with a microdirective should be punishable behavior. So imagine that you are this driver I referred to before who's going down the road and is continually getting real-time commands from the AI as to what speed to drive at, and so on. Or maybe it's going to say, you have to take a break now and rest for 10 minutes, or whatever the case may be. And you say, well, no, I don't think I'm going to, I think I'm okay to continue driving. I don't need to drive that slowly. I don't need to rest. I'll keep going. So you defy the microdirective and you keep going. Is that punishable behavior? I don't have an answer to that question. I think the answer is it depends. And I'm going to try to say something about what I think it might depend on. And again, I'd be very interested to see what people's reaction to that set of questions is. So the first question I wanted to address was whether microdirectives would be of any use in promoting compliance with the rule of law. Sorry, not the rule of law, promoting compliance with the criminal law. And here, when I refer to criminal law, I'm thinking really of the core of criminal law, the offenses against the person, offenses against property, drug type offenses, that kind of thing. And my tentative answer is that in this context, microdirectives would be either useless or pernicious. So let me outline a scenario in which I say they would be useless. The picture of law that the enthusiasts for the legal AI have adopted is a relentlessly instrumental picture. And what I mean by that is that they see law as a vehicle, as a device for achieving certain goals that are in a sense external to the law. Well, some laws are probably like that. And I think it's no coincidence that highway traffic regulation is often used as an example in this context, because even I think that highway traffic regulation probably is like that. But I think a lot of the criminal law is actually not like that. I think a lot of the law in general is not like that, but let's just stick with criminal law for today, because that's something I do know a little bit about. To a large extent, the rules of criminal law are supposed to define things that you're not supposed to do under any circumstances. So if you ask the AI, should I murder my neighbor? The AI is going to give only one answer. No, you shouldn't. Should I murder my father to inherit his estate? What's the AI going to say? It's not going to say, well, yes, if you can get away with it. It's going to say, no, don't do it. So in that context, the legal AI is not going to add anything to what we already know about what our duties are. So for those types of situations, I say microdirectives would be useless. Now, this may seem too quick a conclusion, because we know that even in core areas of criminal law, like the law of murder, there are dividing lines between forms of liability, between situations where people are criminally liable and situations where they are not, that do depend on assessments of things like reasonableness. And the leading example of this type of law is probably the law of self-defense. Now, I don't know anything about the law of self-defense in Hong Kong. And if I tried to tell you about the law of self-defense in Canada, it would be a long and very dull story. And it's totally changed since you were a student, by the way. It's changed completely. So I won't go into all of that. But in a lot of philosophical writing about criminal law, it's argued, and I think this is essentially correct, that a person is justified in acting in self-defense if they face a threat of death or grievous bodily harm, if the response to that threat is necessary, and if the response is proportionate. All three of those elements being assessed from the point of view of a reasonable person. So is a threat reasonably apparent? Is it reasonably necessary to respond? Is the proportionality reasonable? This seems like the kind of question that the legal AI is designed to answer, because it's supposed to take in all the information about all the self-defense cases there have ever been and give some assessment as to whether a person's conduct in a given situation meets the standard of reasonableness. in a way that is supposed to be superior to how that could be done by a human judge or a group of human judges, namely a jury. So could the legal AI do that for us in advance? Remember, what I'm concerned with today is not the prospect of using the legal AI afterwards to sort out a judgment of liability. I'm concerned with the use of the legal AI in advance to tell us what to do or not to do. I suggest to you that for the legal AI to help us know if we're in a situation of self-defense. I don't know about in Hong Kong, but in Canada, there are still a lot of self-defense cases that seem to arise out of brawls in pubs late at night, unfortunately. So if you're hooked up to the legal AI and you happen to get into a brawl late at night, can the legal AI tell you whether you're entitled to act in self-defense or not in that moment? Well, maybe, but I suggest to you that the degree of surveillance involved would be so excessive as to exceed any imaginable boundary of what an acceptable level of surveillance would be in order for that to operate. And this is not, I think, an issue that can be set aside, as some writers on the impact of legal AI on the law have suggested. This is not a normative issue that can be somehow be set aside and decided after we've set up the legal AI and decided whether it works. This is something we have to decide first, because that would have to be in place before it could be used in that way. So that's my suggestion. As I said, these are just suggestions because I don't know the real answers to any of these questions. But in the context of true criminal law, the idea of micro-directives, I think, will either be useless or pernicious. It will be useless because to a large extent, it will just repeat what we already know. Don't steal, don't kill people, don't deal drugs that are illegal. We know all that already, and the legal AI can add nothing to that. And in those situations where there are determinations of reasonableness to be made in determining whether we're criminally liable or not, it would require a degree of surveillance that would be normatively unacceptable. My suggestion. Oops. Can you see it? Seem to have got stuck in some kind of, oh, there we go. So the second constellation of questions I want to address is around this question of whether, regardless of the context, failure to comply with a micro-directive issued by the legal AI should be criminally punishable. This seems like a fairly obvious question to ask. And yet, in the literature that I've read on this topic, I've found very little discussion of it. In fact, I found only one discussion of it. And again, I haven't read everything, and there may be something out there I haven't seen yet. But in the literature I have read, I've only found one discussion of it. Casey and Niblett, in one of their articles on this topic, float the idea of what they call an automatic fine or punishment for violating a micro-directive. They suggest that in this world of command, fact-gathering, and verification technologies may permit immediate notification of a violation of a micro-directive. Citizens' actions could attract scrutiny and punishment irrespective of the ultimate consequences. Penalties could become immediately payable for individuals not following the micro-directive. Okay, so for anyone who is interested in criminal law, there's something quite striking about this proposal. The proposal is that the legal AI would decide first what you should do, should decide second whether you have done it, and should decide third what sanction you should receive for it, presumably a personalized sanction, because this is all about personalized law, without your having the opportunity to challenge what I might refer to as the vires of the directive. That is, was the AI in fact entitled to issue this directive, without being entitled to offer any kind of defense as to why you didn't follow the legal AI. It would be a kind of extreme form of ex ante absolute liability, which for anyone who's interested in criminal law seems like kind of a shocking sort of concept. At any rate, as I say, this is the only passage in the literature so far I've found that discusses this problem. Now, to be fair, Niblett and Casey do consider both advantages and disadvantages to this system of automatic punishment for refusal to comply with the legal AI, but they do not raise the questions which I'm about to raise. So whether this would be punishable behavior, I think depends on what you think the kinds of reasons for punishment are. What is the reason for punishing people and other factors? And I've broken this down into two questions. First of all, where would microdirectives get their authority? What makes it authoritative? This is not, I think, as easy a problem as it seems. And I say this for two reasons. First of all, many contributors to the literature on the legal AI have suggested that these microdirectives might be produced by private actors. So that immediately raises the problem as to where they get their authority, because generally speaking, in criminal law, there's no liability for not following the directives of private actors. It's following the directives, is not complying with the law of the state that gets you into trouble. Secondly, and this is supposed to be one of the advantages of private provision, there may be competing ones out there. And that would not be surprising. In the world of AI, there already are competing ones out there. That is to say, there are competing, for instance, if you're interested in tax, or if you're interested in various other types of problems that have this characteristic of standards of reasonableness being applied in a situation where something fairly quantifiable like money is at stake. There already are competing products you can go to get answers to your question as to what the tax consequences of doing X would be. And I don't know anything about that world, but I would be startled if they all were giving the same answer. So there may be different ones. So where would they get their authority? Would it be, by what process would the state authorize microdirectives to have the kind of authority that would make not complying with them proper subject matter for punishment from a penal law point of view? Would it be possible to challenge the authority of a microdirective ex post in the way that you can challenge the vires of an official command in other situations ex post? In the common law world, for example, it's not the case that you have to comply with everything that a police officer tells you to do. You have to comply with everything a police officer tells you to do that he or she has the power to ask you to do. And so if they ask you to do something that they don't have a legal right to do, you don't have to comply with it. That can be risky behavior from an empirical point of view, but from a legal point of view, it doesn't give rise to liability. So could you challenge the authority of the microdirective in any way? So that's one set of questions. Another set of questions would be, assuming we can solve that set of problems, assuming there's something sufficiently public about the legal AI that produces microdirectives in such a way that not complying with them could be a wrong, the kind of wrong that the penal law typically takes account of. Should this be punishable behavior? Going one step back, should it be an offense to fail to carry a phone? I put phone in quotation marks because what I'm referring to is any device capable of conveying microdirectives to you. I wasn't going to put phone in quotation marks, but I was reading something the other day about the next generation Google. There was a thing called Google Glasses, and they don't have them anymore, but they're bringing them back apparently. So there's going to be something else. It's not a phone, but nevertheless would have the capability of conveying these directives to you. Should that be an offense? If so, what would the elements, to look at it from a criminal law point of view, what would the elements of this offense be? What would the appropriate penalty be? Wouldn't everyone inevitably become an offender under this structure? Because it's not, I can't imagine that there would be 100% compliance with microdirectives by everyone, no matter how well motivated they were from a social point of view. So the answer here is it depends. It probably depends on what your theory of punishment is. And here I'm just going to be oversimplify in a kind of brutal way and not try to answer this question, but just try to sketch out what I think might be the possible lines of attack on this question. Some theorists of punishment are purely consequentialist. And I think it's no coincidence that the people who came up with this idea of microdirectives, and more generally the people who work on personalized law, tend to come from an economics analysis of law background. That tends to be the background they came from. And they, of course, do have a completely consequentialist theory of punishment. anything. For them, punishment is just a lever like any other consequence that can encourage people to comply with the law they're supposed to be complying with. So they tend not to be that interested in the questions that criminal law theorists are interested in. What's the moral quality of behavior that makes it punishable? What kind of judgment of responsibility is embedded in a finding that a person has committed an offense? These are not questions that are really at the top of mind for economic analysts of law, and more generally for people who are enthusiasts for what I've referred to as the legal AI. So if that's your view, there actually probably is no problem here. But not everybody has that view about criminal punishment or penal law more generally. Many people think that a finding of penal liability implies some kind of moral fault in the offender. What exactly that moral fault is, how we should describe it, is a very controversial question. Very roughly, I think we can distinguish between what I will refer to as the legal moralists and what I will refer to as the juridical retributivists. Now, some people might be surprised that I would put Anthony Duff and John Gardner in the legal moralist camp, and I'm not sure I can fully defend that position today. But the point is, I think that each of them, in their own way, they're not the same by any means, but each of them tries to identify some quality in someone's conduct that makes it suitable for criminal punishment from a background moral point of view. And that's why I put them in the legal moralist camp. In this camp, there's always been a problem about regulatory offenses, and I don't think there's any question that failing to comply with a microdirective would have to be some kind of regulatory offense, because the immoral quality of committing a regulatory offense doesn't immediately jump out at you. So there would have to be some account of how failing to comply with a microdirective could be assimilated to their accounts of why it's acceptable from a moral point of view to punish people who've committed a regulatory offense, such as exceeding the speed limit. For the people I'm going to call the juridical retributivists, sometimes referred to as the public law view of criminal law, there's something about the commission of a criminal offense that is in some way a challenge to the idea of a rights-based legal order. That's what's, I think, essentially going on in these accounts of criminal law. So they're not rooting the punishable quality of conduct in a moral wrong, although there may be an overlap. They're rooting it in some idea of the offender trying to set himself aside from the publicly promulgated set of legal norms that's supposed to govern us all so that we can relate to each other in a rightful way. And so again, for these scholars, if they could swallow the idea of microdirectives at all, which I think is a questionable proposition, but assuming they could, there would have to be some account of how that related to the kind of challenge to public authority that criminal offending is supposed to have. So I don't know what any of this would look like. Honestly, I'm just raising it as a set of problems. I'm raising it as a set of problems because reading this literature, I was startled by how little attention was paid to these questions of how personalized law in general and microdirectives in particular might interact with penal liability. And on the last two slides, and I don't know if the audience has access to the slides, but you should feel free to send them on to them if you want to. The last three slides, I just have some citations to some of the things I referred to during the slides. So I'm going to stop there. That's all right with you.
All right. Well, we set an hour for this seminar, but I think we could go on for a long time. But as I said at the beginning, this is really, of course, a preliminary seminar on the topic for us. Preliminary for you as well, Professor Stewart, which means that you'll have to come back once your thinking is advanced and other things have advanced as well. But I think it's been a really enjoyable seminar. So can you please join me in showing your appreciation for Professor Stewart?
Thank you very much.
Thank you.
Thank you.